The CRA loves to call aggressive tax planning a sham, but in Canadian law that word means something very specific, and it's a lot harder to prove than most people think. Hello, I'm David Rotfleisch, a Canadian tax and business lawyer and a certified specialist in taxation. Welcome to the TaxPage Tax channel. A sham isn't just an aggressive transaction or one that saved you a lot of tax. It requires deceit. The parties have to present their legal rights and obligations in a way they know doesn't reflect what those rights and obligations actually are. That's very different from tax avoidance. Courts have said for decades, going back to Stubart investments in 1984, that you're allowed to structure your affairs to pay less tax. A transaction motivated purely by tax savings is not on its own a sham. Take Cameco. The CRA argued a major cross-border corporate structure was a sham. The tax court disagreed. The contracts reflected exactly what the parties intended. By the time it reached the Court of Appeal, the CRA had dropped the argument altogether. And here's the part most people don't know. Once the CRA alleges sham, the burden shifts. The CRA has to prove it, not you. And to be clear, a sham finding isn't a criminal conviction. It's decided in civil tax court on a balance of probabilities. Tax evasion is a separate criminal offense, and the CRA has to prove that beyond a reasonable doubt. They're two very different things with very different consequences. Contact one of our tax lawyers at taxpage.com. We're here to help.